Bonsoir, bienvenue, good evening. Welcome here at Villa Moignier, good evening, and welcome, good day for all of those who are joining us online today. My name is Felix Kirchmeier. I'm the Executive Director of the Geneva Human Rights Platform, and it is my pleasure to welcome you here tonight to this discussion on climate justice hearings at the International Court of Justice, unpacking key arguments and drawing lessons from a human rights perspective. Welcome, Excellencies, colleagues, and friends. Good evening and warm welcome. Thank you for being here, Ambassador. Let me begin by thanking our partners, the Geneva Environment Network, the Center for International Environmental Law, CIEL, World Youth for Climate Justice, and Earthjustice. Your collaboration has made today's event possible. Let me also announce at the very beginning that we are actually recording this event. We'll make it available later on also on our YouTube channel. So the event is public and being recorded. So just that you all know that. 10 days ago, we hosted a commented public screening of the first day of the hearings at Palais des Nations, jointly with this group of co-organizers. And today it's the moment to debrief on 9 days of important discussions where the ICJ tried to clarify states' legal obligations regarding the climate crisis, focusing on the protection of present and future generations and the environment. As CIEL powerfully stated on 2nd December, today is the day we're taking the world's biggest problem to the world's highest court. These historic hearings at the ICJ are a defining moment in the fight for climate justice. Today, we will have the privilege of hearing from representatives of member states and actors who were directly involved in the hearings. They underscored there the decisive role that UN human rights mechanisms, including also the treaty body system, play in advancing climate justice. This is a powerful reminder of the unique and indispensable contributions of International Geneva, also as the home of those human rights mechanisms. Geneva not only informs international processes, but also builds on their outcomes, serving as a hub where the principles of human rights and climate justice converge to drive global progress. And of course, Geneva is not alone. For years, the Pacific Island states have led the climate justice movement, championing this effort to seek an authoritative opinion from the ICJ. Their warnings about the existential threats posed by climate change have often been ignored. Big polluters have denied their responsibilities and stalled negotiations, as seen in the disappointing outcome of COP29 in Baku. These hearings, however, provide a chance to establish accountability and to deliver a clear message. Polluters cannot evade their legal obligations. As Professor Alston, actually, Philip Alston reminded us just some weeks ago at our annual conference of the Geneva Human Rights Platform, the strength of the human rights system lies in its adaptability. He compared it actually to a game of whack-a-mole, which might not be technically a very environmentally friendly term. When one actor actually falters, another steps up to fill the void. And similarly, in the fight for climate justice, progress is not confined to one institution or path. Whether through grassroots activism, judicial rulings, or civil society advocacy, the struggle for accountability continues. The ICJ hearings exemplify this resilience. Where politics may fail, judicial processes create new avenues for action. These hearings are not only about clarifying legal obligations, but also about amplifying voices from the front lines and reinforcing the interconnectedness of human rights and environmental law. This evening, we'll hear first from a panel of experts the introductory remarks, actually. So we'll ask everybody to speak for 5 minutes, and then we'll switch the panel and we get into the guided discussion that my colleague from CIEL will be moderating. So just for you to know how we plan to go through the evening. And it gives me immense pleasure to invite our first speaker, His Excellency Sembue Antas, Permanent Representative of the Republic of Vanuatu to the UN here in Geneva, to take the floor. And Ambassador, if you could reflect, of course, on Vanuatu's key takeaways from the past 9 days of hearings. So the floor is yours, and thank you very much, Ambassador, for being with us.
Thank you, Felix. Good evening, everyone. And I don't know whether this is online as well?
It is online, yes.
And good evening to those who are watching us online. Welcome to this evening's event. I should start by saying that I'm looking at these pictures here, and I'm looking at the young people who are waving their flags or waving whatever they have, placards at The Hague. And because this exercise started with young people, our young people, who in the Pacific decided that this was an issue that they would wish to pursue, and rightly so. And we're very thankful for their activism. And when they then approached the government, and the government decided that they would look into this. They listened to the young people from the Pacific, with a lot of supporters from the international youth movement as well, and many NGOs and many governments. So you saw what happened during the last week and also today, in this week, and you saw what happened at The Hague. So the question being asked of me is to touch on the Vanuatu's leadership in these proceedings, alongside the frontline states on climate change and the inspiring work. But the inspiring work, I must say, started from young people. So it's very important for people like me who are much older to listen to the young people, because they are the ones who are affected and our future generations. These last 2 weeks, we have seen history being made. We saw countries made submissions, oral submissions, and as has been said by Felix, in the global world's biggest court, the biggest climate case, with unprecedented participation from nearly 100 states and organizations, highlighting the urgency, the scale, and the devastating impacts of this crisis. And we have seen this presented by the various countries, the various submissions. This last 2 weeks, we heard the oral arguments, and these hearings came on the heels of COP29, where once again, we did not see climate talks deliver on climate justice. Multilateralism will always remain a cornerstone of our international relations, but it is beyond time that climate ambition is rooted also in existing legal obligations. As we Vanuatu have emphasized at the ICJ hearings, the quote, prolonged and systematic failure of the COP process, unquote, has cost our people their well-being, their cultures, and even their lives. In the past, in the last week, the last month, last week, and even today. The call for an advisory opinion from the ICJ on climate change is towards establishing a stronger framework of accountability. And we have already explained what were the 2 questions being raised, which was asked of the ICJ to respond to. And we heard in the last 2 weeks, and even today also, or during this week, historical polluters and a few fossil fuel dependent economies tend to advocate for the Paris Agreement to be considered as the only international law relevant to climate change. However, Vanuatu and a large majority of other states and intergovernmental organizations also recognize existing legal obligations applying under many legal sources, including the Charter of the United Nations, the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights and on Economic, Social, and Cultural Rights, the Convention of the Rights of the Child, and others. During the ongoing hearings, many states across the global north and global south spectrum have reinforced the importance of human rights in relation to defining state obligations in regard to climate change. This has been a very powerful time to witness. We are, of course, disappointed We are, of course, very disappointed by major polluters, many of our friends, who have sought to dismiss the applicability of human rights in the climate context, and more broadly, evading their legal responsibilities. We heard that very clearly last week and this week. These nations stress a cooperative approach, but cooperation and responsibility are complementary. They can and must go together. As sea levels rise and around the world, we see intensifying climate impacts. We must act. Act with ambition, act in solidarity, and act to meet our legal obligations. There needs to be an accounting for the failure to curb climate destructive conduct and the resulting human rights violations. And can all agree that the ICJ proceedings are about our shared humanity and legal accountability. What lies ahead? What's ahead of us? Looking forward, a strong opinion from the world's highest court on the legal obligations of states, drawing on the full spectrum of relevant international law to prevent climate change, protect people and environment from its impacts, and remedy climate harms. Will help be vital to advancing our climate change and human rights. Thank you for coming this evening, and I'll listen with interest to the other panel members as well, and also from you, the audience, for any questions and comments. And I thank you very much. Thank you.
Thank you. Thank you very much, Ambassador, for your opening words, saying how we are seeing history being made. Thank you very much for this. And I'm turning now actually online to a speaker, to a video message, to be more precise, of Elisa Mordera, UN Special Rapporteur on Climate Change and Human Rights, who we asked to reflect on the role of the advisory opinion in centering human rights at the core of climate responses. So if you could show the video, please.
Dear colleagues, I'm sorry I can't be there with you in person in Geneva, and I would like to thank World Youth for Climate Justice and all their supporting organizations in Geneva for co-organizing this important conversation. I've been following the oral hearings before the International Court of Justice at a distance while conducting my first country visit to Vanuatu, and also while now this week being in Kuala Lumpur to contribute to the scoping meeting of the Intergovernmental Panel on Climate Change. The first reflection I would like to share with you is the lack of credibility of the arguments that have been made time and again before the court about the applicability only of the UN Framework Convention on Climate Change and the Paris Agreement to the matter at hand. Those arguments can't possibly be taken seriously without those states engaging more explicitly into a much greater level of detail with the intervening advisory opinion of the International Tribunal for the Law of the Sea, which has made abundantly clear that climate action, even if it may be in compliance with the Paris Agreement, does not exempt states from complying with obligations under other international treaties, the objectives and obligations of which are undermined by climate change. And so other international treaties, even where they do not mention climate change, can and must be interpreted so as to contain obligations to mitigate and adapt to climate change and to provide international finance to developing countries who are most affected by climate change and have least contributed to it. The same can be said for international human rights law. Insufficient or ineffective climate action, even if it may be considered in compliance with the Paris Agreement, does not shield states from applicable international human rights obligations and from their international responsibility arising from breaching of such obligations. Of course, those arguments about how carefully crafted the Paris Agreement was and how still careful intergovernmental negotiations are about its implementations are hard to believe in the aftermath of COP29, where we've seen little, if any, progress on mitigation, where we've seen little, if any, meaningful progress on international finance, and where we've seen severe problems in terms of multilateral decision-making, as well as in terms of public participation and consideration of science, indigenous knowledge, other knowledge systems, and the lived experiences of those human rights holders who are most affected by climate change. It has been also really important to see how children and young people were able to be heard, if not during the oral hearings, around the oral hearings. I think states' obligations to hear children and to protect children's rights in the context of climate change are crucial. And I was maybe surprised that not more states engaged and build their arguments on the Convention on the Rights of the Child and General Comment 26 on children's rights to a healthy environment. My final set of reflections has to do with the consequences under international law that the Court of Justice has to clarify, and of course, the very impressive opening statement by the Vanuatu team, who was so remarkable in terms of clarity, comprehensiveness, and cogent nature of the argument and interpretation put before the court. It is essential for the International Court of Justice to explore the full range of remedies under general international law and under international human rights law. And through that, clarify that the international financial norms under the international climate regime, but in fact, under other international environmental agreements, are legally binding, both as a matter of primary and secondary international obligations. In addition, the guarantees of non-repetition provide a crucial opportunity to reevaluate and reprioritize climate action in terms of clarifying state obligations to phase out fossil fuels, as well as fossil fuel subsidies, and also prioritize biodiversity conservation and restoration as a matter of climate mitigation and adaptation, which was also very much underscored by the International Tribunal for the Law of the Sea. And the final critical point is about the modalities, how those remedies will be identified and applied, which needs to be as a matter of shared determination with the states and the frontline communities who have been most affected by climate change. There's a very clear need to move away from the current system where donor states are not responding or even listening to the needs and the knowledge of the states and the communities who have been most affected by climate change.
I would like to thank Elisa for that statement and also for recalling those points regarding to remedy in particular. And turning now back here to the room to another special rapporteur. Thank you very much, Astrid Puentes, for being with us here. Astrid Puentes, UN Special Rapporteur on the right to a clean, healthy, and sustainable environment. And Astrid, obviously, we'd like to ask you whether you could shed light for us on the state's interventions in relation to your mandate to the right to a clean, healthy, and sustainable environment, and how actually this right can guide effective climate action. So the floor is yours.
Thank you very much, Felix, for your remarks and the invitation. And first of all, I apologize for being so late. I guess that I walk in another path, actually, from Olivier and other special rapporteurs in the meeting that we were. And so that's why I was late, but I'm glad that I was just on time. So regarding the interventions of states at the hearings at the International Court of Justice in relation to the human right to a clean, healthy, and sustainable environment, I want to highlight that, as you probably have seen, there we saw the reflection of tendency and arguments that we have seen from by some states. So the first thing to say is that the majority of the states have included the right to a healthy environment and have referred to a right to a healthy environment, even if in a negative way, or saying that the UN resolution is non-binding. But the fact that states are highlighting the importance of the right to a clean, healthy, and sustainable environment as a human right is very important. The second point that I want to make is that the vast majority of the states have highlight that not only referring that the right to a clean, healthy, and sustainable environment is actually part of customary international law, but they have highlighted, as we also have seen in different decisions, that the right to a healthy environment is also needed in a way to interpret and to be able to help grant and have the evolution and achieve the evolution of international law that we need. We have heard two group of arguments. One is referring to the UN resolutions, both at and especially the UN resolution in the General Assembly, whether it is binding or not. And so regarding that, I want to say and remind, of course, ourselves that the vote at the General Assembly 2 years ago reflects the importance and the political support, of course, the right to a healthy environment has, with 161 states positive. There was 0 votes against and only 8 abstentions. But highlighting also that today, even if the discussion is whether the UN resolution is binding or not, today we have 164 states that include either in their constitution or legislations the right to a clean, healthy, and sustainable environment. So that gives us a clear perspective about that 85% of UN states today recognize the right to a healthy environment in their legislations. In addition to that, regionally, and this is not 2 years ago, for decades, the African system and the Inter-American system has recognized this right. And so thinking about how customary international law is created and it's recognized, we need consistent and widespread practice from states and opinion juries. So we have 85% of states. So not only the resolution, but we have a massive amount of states that for decades in the 70s have recognized this right. And we also have opinion juries. There are several decisions from the Inter-American system and also from the African system that talk about this right. We also have treaty bodies, of course, mentioning that. And we heard the Special Rapporteur, Lisa, talking about the Committee on the Rights to the Child and other treaty bodies. And we also have, even at the European Court of Justice, where, of course, the right is not expressly recognized, the court is talking about the right to a healthy environment. So that's very important. And let me finish with one very important thing to highlight. This is not the conversation. We should not be talking about formalities, whether a UN resolution is binding or not. We need decisions. We need actions in the ground. And in that way, the right to a healthy environment is a tool that can help states, all states, to advance and land the actions that we need so that we can recognize and guarantee and fulfill the right to life, the right to all other human rights. Let me just stop it there, of course, including the rights to children and present and future generations. So I really hope that the International Court of Justice listen and takes into account all the development of the right to a healthy environment, and hopefully we will see a strong and decision that helps us see the evolution of the law and international law that we need. Thank you.
Thank you. Thank you very much, Astrid. And if I may turn now to my left to Marcelo Cohen, Emeritus Professor at the Geneva Graduate Institute of International and Development Studies. And Marcelo, ask you to address how you and other legal counsels involved actually address the relation between human rights obligations and the obligation of due diligence and the Paris Agreement, and your expectations from the court actually in those regards. So please, over to you.
Well, thank you very much, Felix, for this invitation. I have to say that I spoke on behalf of Costa Rica last week before the ICJ. What I will say here is my personal comment only. I would like to continue the analysis of the right to a clean, healthy, and sustainable development, because I believe that this is one of the crucial contributions that the ICJ can adopt in its advisory opinion. As Astrid mentioned, so there were different views, and it was deeply regrettable to see some states like Germany, Saudi Arabia, Canada, Indonesia, the USA, and Russia challenging the existence of this right. Costa Rica was one of the leading countries supporting this idea of the existence of this right. The arguments were that, well, this is a political recognition. That's very strange because if you vote in favor of a resolution telling that there is a right, how can you explain that then? Well, it's a political recognition. That's not a legal one. So Costa Rica remembered the court that it was so the case for the Universal Declaration of Human Rights. It's a resolution of the General Assembly. And also, we mentioned the fact that this is a situation in which you can compare this right to a healthy, clean, and sustainable environment with the right of peoples to self-determination, because there was exactly the same discussion in the past. Was it a legal right or a political aspiration? And now, well, we have the covenants, 1966, but it took a lot of time to have this recognized as the premise for the enjoyment of all the other rights. And the same here, because this right is a premise for the enjoyment of all the other, the right to life, the right to health, the right to food, water, etc., etc., etc. So this is one point. With regard to the applicability of human rights. So the major polluters or the producers of fossil fuel, well, they invoke that the lex specialis only the Framework Convention, the Paris Agreement, nothing else. You don't have to look at the human rights. You don't have to look at the environmental law. By the way, general international law rules. And then with regard to human rights, there was something very strange, I would even say, also from the same countries I mentioned. That is to say, there is no extraterritorial application of human rights. Big confusion, I would say. And this is what we said before the ICJ, because no matter, we can discuss whether states having become parties to the Convention on Human Rights, where lies their responsibility? Only within the territory they have jurisdictional control or beyond? But what about customary international law of human rights? Is it possible to even conceive that states are allowed to violate human rights beyond their territories or the territories they control? This is a deeply regrettable position that some states have adopted. Then there is the question of due diligence. And I believe many states that in the written phase, they have insisted on the lex specialis argument. They realize that this is not a good argument, although some of them insisted. But then they say, well, okay, so we can apply the due diligence, but they try to narrow the scope. And one of my concerns, I have to say, is the fact that many states confuse and put too much emphasis on due diligence, which is a general international law rule. It's not only applicable in the field of environment. Due diligence, states have to adopt a policy of due diligence in the protection of diplomatic premises. Due diligence is something general. But then we have the specific rules concerning environmental law. Prevention is one aspect, but the main obligation that it is at stake here is the obligation not to cause significant transboundary harm. And this is one of the questions that we will see whether the court will be able to distinguish these three different kind of obligations. The other point, I don't know whether I still have time or not. Obviously, the main element here, and this will be the most problematic point for the ICJ, will be the question of the applicability of the law of international responsibility for international wrongful acts. again, so the position of the polluters was, well, only to answer the second question, you only need to have a look at the obligation that states have adopted in the conventional regime. And this will be one of the major points that the court will discuss. I try to keep hope, and I believe that during the presentations last week, this week, until today, the arguments in the direction of the applicability of the law of state responsibility for wrongful acts, I believe they were very convincing. Well, I don't have to convince myself, but I believe that they were convincing. I wouldn't like to make, I don't have the crystal ball, so I don't know what the court will decide, but I do believe that the court will not accept the lex specialis argument. I do believe that the court will apply human rights, the general international rules on environmental law, and then the necessary consequence should be to take into account international responsibility for wrongful acts. Well, this is my hope, and we will see what will happen next year. Thank you.
Thank you very much, and hoping that your hope will be needed. Let me come to the last speaker of this round, because Vijay Prasad also is supposed to be online with us, but not at the moment. So we'll see whether he might come in then later again. Let me turn to Luc Dockendorf, Deputy Permanent Representative of Luxembourg to the UN here in Geneva, and invite you, Luc, to reflect on the upcoming advisory opinion as an opportunity for states to uphold their human rights obligations actually and advance in international cooperation. So please, over to you, Luc.
Thank you very much, Felix, and I will try to keep time because there is so much to say about this, although I'm not the best qualified person to say it. But Ambassador, you started by alluding to the young people who are demonstrating in The Hague. And almost to this day, 24 years ago, I was a student myself demonstrating in The Hague at COP6, which was a long time ago. I suppose everybody was born in this room, but still, that was back then. We built actually a wall of sandbags around the conference venue, and that could be seen as either, well, we're locking you in there until you get an agreement on the climate, or we are protecting you from the rising waters. And I think that's that. I mean, the youth of today is still sending this message. You are deciding over our futures, and you have to decide, do what's right. One of the points I'd really like to make is that states are complex and not monolithic things. I don't know if we have a better word for things. And that's something that we need to engage with both as diplomats, of course, like ourselves, but also academics and civil society. States don't always do the right thing, even when they should know better, and normally they do know better. I think we are hearing this in The Hague right now. I speak not on behalf of my state, but rather as my personal opinion, because we are not speaking at the hearings. Unfortunately, I found out no later than today. Although I've just gotten guarantees from my colleagues in the Ministry of Environment that our ambitions are going up rather than down. So we had 220 million for international climate action for the last 5 years, and I hear we're going to have more for the next 5 years, which isn't going to solve everything on its own. I think an important principle to remind ourselves, because we are here in Geneva and we talk about human rights rather than only about international law as they do in The Hague, is that there is a fundamental difference between the rule of law, where law is used to protect rather than to protect the weak rather than to protect the strong, and that's ruled by law. And there is danger that the lawyers who are now speaking at the hearing sort of confuse the difference between the law and justice. And there is a dimension here, I think, of international justice, of intergenerational justice, also of historic justice, of making up for well over 100 years of extractive, industrialized systems, not only in the countries themselves, but exported through colonialism and through historic wrongs that have not been righted yet. And I think it tells you a lot about whether states, or rather the individual representatives of states, whether at the Court of Justice or at the Human Rights Council, are willing to deal with the past, are willing to recognize that responsibility and do what's necessary to make up for it. And Special Rapporteur, you alluded to the importance of guarantees of non-recurrence, and I think it's important to adopt also a framework of transitional justice to this. And one of the pillars is, of course, promising not to, well, apologizing, giving reparations and promising not to do it again. Professor Cohen, you spoke a lot about negative and positive obligations of states, and I think it is very high time that we switch towards the positive side, towards the doing rather than the not doing, although there is a lot of not doing that is still necessary. There's a lot of pollution that's still going on, and that we're not getting under control by the existing frame of mind in which most state representatives are in. There is also a clash of, I think, interests within every state, as within every society, that we need to be aware of. It's relatively easy to get diplomats who work at the Human Rights Council to recognize that there is a problem and that there is a right to a clean, healthy, and sustainable environment. It is rather harder to get the same state's representative to the World Trade Organization or to other places, and sometimes there are really rather difficult debates inside each ministry, inside each government, principles are very often, I still have 30 seconds, principles are very often weighed against short-term, very often economic interests, and it's important for states to get that right. I think the core that we have in the idea of state responsibility and also the UN Charter and the rest of the international law body that we are supposed to respect is that there is a social contract that should also apply at the international level, that states are duty bearers vis-à-vis rights holders, and that they also need to recognize that these rights are not only for citizens, but for everybody around the planet, especially states that have either a very large extractive hydrocarbon industry or that, like my own, are very large polluters. And I think that's that principle we can at least agree on. Thank you.
Thank you very much. And well, a round of applause to all the speakers to all the speakers of the first round. We'll quickly switch now here on the podium, and I'd like to ask Joy Jarduri of Ciel to replace me in the moderation, and Olivier Descruter, Surya Deva, Ana Maria Suarez Franco, Evelyn Schmidt, Geneva Lemoli to join us up here, please.
All right, so we're going to start straight away the second panel, and after that we'll have the chance to discuss and have a Q&A. We heard our incredible panelists from the first panel, and thank you so much for those rich observations. But to ground us a bit before we go into our discussion, let's take a closer look at one of the oral interventions we heard today from the court. Tuvalu's oral intervention was a sobering one. They spoke today. Despite producing less than 0.01% of GHG emissions, Tuvalu is expected to be the first country to be completely lost to climate-related sea level rise. And the injustice here is staggering. Catastrophic climate harms are fundamentally interfering with their basic human rights. Tuvaluans are doing everything they can to preserve their nation from extinction through land reclamation activities, even exploring a digital nation initiative to recreate Tuvalu's land, culture, and government in digital form. I want you to sit with that for a moment. They're having to consider digitizing their nation, their home. They're in a struggle against erasure. Meanwhile, as you have heard from our panelists, we have heard over the last couple of weeks major polluters throughout the hearings engaging in playing the legal system to prioritize narrow self-interest, doing their utmost to evade and dilute their legal duties, as states are facing the threat of disappearing altogether. And it is time to break this cycle of harm and impunity, and the court has a solemn responsibility to hear Tuvalu's call, which they made today to the ICJ, to keep the right to survival, the right to self-determination, at the very center of its critical advisory opinion. The delegation quoted a Tuvaluan climate activist who powerfully said Tuvalu will not go quietly into the rising sea. As was stressed by the panelists today, these oral pleadings this week made clear that this is a watershed moment for climate justice, for human rights, and legal accountability. And to bring back the conversation to the core questions at the heart of the proceedings. The very first day we saw the joint intervention of Vanuatu and MSG compellingly argue that the conduct responsible for climate change and its catastrophic consequences, driving humanity to the brink of extinction, that conduct is unlawful under multiple sources of international law, extending far beyond the Paris Agreement, including human rights law, law of the sea, climate and environmental law, and customary international law, as Professor Cohen mentioned as well. This unlawful conduct then triggers legal consequences, which is seizing the climate destructive conduct, guarantees of non-repetition, and the provision of full reparation. In the course of the hearings, we have seen, and this has been so moving, so inspiring, such a strong defense of human rights by so many countries: Costa Rica, El Salvador, Spain, Fiji, Chile, the Philippines, Cameroon, Colombia, Bolivia, Albania, Slovenia. There are so many, and the alignment has been extraordinary. The critical issue of extraterritorial obligations, absolutely essential in the context of climate change, has been championed by a number of states. And we have also seen big polluters, on the other hand, seeking to deny and dilute their legal responsibilities in the face of devastating human rights harm by outright rejecting or restricting its application to climate change. And it is frustrating to watch major emitters set our rights on fire and then deny the rightful application of human rights law. Particular areas that emerged as focal points, and our incredible panelists have touched on it, and our discussants will as well, has been the right to a clean, healthy, and sustainable environment, the right to development, and the rights of future generations. As multiple panelists have emphasized, and the importance of this cannot be overstated, central to these proceedings, even a flashpoint, has been the second question posed to the court, addressing the legal consequences of climate destructive actions. The principle that when there is a right, there must be a remedy is a cornerstone of justice and human rights. Accountability and reparations for climate harm are obligations. They are not acts of charity, whatever cops would have you believe. At the hearings, while the world's major polluters attempted to tear apart the legal arguments to establish the claim for reparations, their arguments were forcefully countered by many of the world's most climate vulnerable nations, who persuasively set forth the legal basis for climate reparations proportionate with climate harms and the applicability of secondary obligations under conventional and customary law. In The Hague, as Elisa so beautifully mentioned, calls for remedy and reparations went beyond monetary compensation for material and non-material harm. Structural measures such as equitable fossil fuel phase-out, non-reliance on measures which may exacerbate harm, colloquially known as false solutions, such as geoengineering, eco-restoration, tributes to victims, debt cancellation. And just to wrap up here, as was mentioned by Mr. Dockendorf, there are structural issues at play. How climate impacts are experienced as human rights harm is rooted in intersecting systems of oppression, such as unjust global financial architecture, entrenched inequalities, the perpetuation of colonial legacies. These are not abstract issues, they are lived realities for millions. And the structural links between climate harm and systemic injustice has been made unequivocally clear in the oral proceedings, reminding us that the fight for climate justice is also a fight for equity and dignity. So without further ado, I'm going to turn to our esteemed discussants. And we first have you, Olivier. Olivier Deschutes, all of us know him and love him, I think, in this room. UN Special Rapporteur on Extreme Poverty and Human Rights. What has been your reflections, Olivier, now that you're hearing the statements unfold and you've heard the panelists? We would love to hear from you on the questions posed to the courts and the arguments that states are making.
Thank you, Joy. I am tempted to discuss in greater detail even what was said about extraterritorial human rights obligations and the question of the United Nations Framework Convention on Climate Change being a lex specialis. I will refrain from doing so because in the mandate I was given, I meant to focus on the issue of poverty in relation to climate change. I know that others on this panel will pursue in detail the other aspects, many aspects in the case. The reference to poverty in the proceedings was made in two very different ways. First of all, a number of states, and I should like to mention Kuwait, Saudi Arabia, China, and India, referred to poverty by saying essentially that climate change mitigation should be balanced against the imperative of poverty eradication, which should take priority. To eradicate poverty, economic development is required, access to cheap energy is required, which, for example, would counsel against the imposition of carbon taxes or the removal of fossil fuel subsidies. And these states have based that argument, in particular, on the UN Framework Convention on Climate Change itself, that mentions, in particular, in Article 4, paragraph 7, that developing countries' commitments under the UNFCCC, I quote, will take fully into account that economic and social development and poverty eradication are the first and overriding priorities for these countries. So that position is that there's a trade-off between eradicating poverty or mitigating climate change, and that economic development, growing the metabolism of the economy in order to create growth, should take priority, particularly for developing countries. Again, those making these arguments are Kuwait, Saudi Arabia, China, and India in particular. And then there are many other countries who mention poverty, but in a very different way. And I could mention the Barbados, Côte d'Ivoire, Spain, Fiji, Ghana, the Cook Islands, Papua New Guinea, the Netherlands, Peru, Sudan, Sri Lanka, probably others which I'm omitting, and many of them are low-income countries, who instead emphasized that climate change was an assault on people in poverty. And that if we want to truly combat poverty, we must first ensure that these people do not drown, and are not further impacted by droughts, floods, landslides, which they are the first victims of. And against the background of that exchange, I think three messages should be recalled. The first one is that people in poverty are indeed the most affected by climate disruptions. And my predecessor, my esteemed colleague, Philip Alston, made this argument in a very powerful report presented in June of 2019 to the Human Rights Council at the 41st session of the Human Rights Council, in which he highlighted the various ways in which poverty was made worse by climate change and how people in poverty were the first affected. Let us recall that according to the World Bank, by 2050, more than 216 million people will be forced to migrate internally as a result of climate change. 130 million more people will be driven into poverty as a result of climate change. Crop failures will increase, leading, according again to the World Bank, to a 12% increase in the price of food in sub-Saharan Africa. Heat stress will reduce work productivity with particular impact on manual laborers. People in poverty are the most affected by air pollution in cities, by floods and landslides, as they cannot easily choose where to live. They build their dwellings in risky areas because they have no choice. That is where it is affordable. People in poverty are also going to be the most affected by climate change because it is these people who depend the most on access to natural resources for their livelihoods. Many small-scale farmers affected by droughts and floods. Many indigenous peoples depending on forests for their subsistence. 400 million people across the world. These are those who will be the most affected by climate change. People in poverty are the first victims. That is the first message. The second message is that contrary to the easy assumption that poverty eradication and climate change mitigation would be competing objectives, in fact, we can address climate change by adopting measures that actually contribute to poverty eradication. There is no trade-off. There is a synergy, there is a complementarity. And in the very first report I presented in my new role as Special Rapporteur on Extreme Poverty and Human Rights to the General Assembly in October 2020, the report is called The Just Transition, Eradicating Poverty Within Planetary Boundaries. I tried to make that argument, and I tried to show very modestly that in various areas, mobility, food and agriculture, housing, building, and energy, we can adopt many measures that are what I called triple dividend measures, mitigating the environmental impacts, creating jobs, and ensuring that goods and services that are essential for a decent living, for an adequate standard of living, can be made affordable to low-income households. And of course, we have no time to enter into the details, but that can be done. There is no trade-off. There is no need to choose. Moreover, I tried to show in that report how combating inequalities is essential to the mitigation of climate change, and that, of course, is in the interest of eradicating poverty. And the third message, finally, is that poverty eradication does not depend on infinite economic growth. And that was my last report, as some of you may recall, to the Human Rights Council, presented last July. The title of that report is Eradicating Poverty Beyond Growth. And I try to show, again, with great humility in this report, that the focus on increasing the GDP as a condition for everything else is mistaken. That this is a distraction from what really matters: eradicating poverty, reducing inequalities, achieving well-being for all. And in fact, the focus on increasing the GDP can be counterproductive because of the policies we adopt to grow the economy. We create the very social exclusion and the very inequalities that economic growth was meant to respond to. So that is what I've seen from the proceedings. I would like to thank you for organizing this important discussion. And I very much hope, like all of you, that The initiative that Vanuatu has taken, I would like to congratulate Vanuatu again for putting this issue on the docket of the International Court of Justice, that it will be successful. Thank you.
Thank you very much, Olivier, for those very insightful comments and your take on systemic solutions to the climate crisis. Suryadeva mentioned that he would be late to the session, so he's not here, which is a pity because on the right to development as well, like in poverty, we have seen the terrain of arguments being very complex, while the issue of equity ran as a common thread for the most part. We saw divergence based on the use of the right to development to justify very energy fossil fueled production. And on the other hand, we saw the right to development being states making the argument that the right to development is actually hindered when there isn't ambitious climate action. So there are these divergent point of views as well, which would be interesting to unpack. But Surya is going to come and then we're going to have that conversation together. In the meantime, I'm going to turn to Anna Maria. Anna Maria, we have seen repeated stress by different State Council on the importance of the rights of future generations and intergenerational equity. And we've heard others who found it hard to confer rights on future generations, justiciable rights. So it would be wonderful to hear your point of view on all of that.
Yes, thank you very much, Joey, to all of you for being here. It was very inspiring to hear the previous panelists and our chair here. I was counting more or less the opinion and found 32 states in favor of the recognition of future generations or mentioning the intergenerational justice, and 5 states against. I will not list them, but I can say that from the 5 that we're against, 4 are from the global north and very powerful industrial countries. So more or less to show how is the situation. And I found very important that states like Vanuatu again emphasized on the impacts and how the impacts will not be in the next 5-6 years, but are long-term. And of course, the impacts of climate change also affect the other planetary crises like pollution and especially the destruction or loss of biodiversity that is connected to the impossibility of people to enjoy their human rights in general, and is also connected to other of the crises that our humanity and nature are living. And of course, these impacts of climate change get worsened when we see, and something that you mentioned, Joy, and it's the financialization of nature or the digitalization of nature, which is proposing false solutions, like, for example, geoengineering you mentioned, but also carbon markets that are impacting adversely also on the people, not only in the global south, but also in the global north. And all that brings us to the same message that Olivier mentioned and was mentioned by many states, and this is that our production model cannot continue growing at the cost of the humanity and nature. And I hope that the court recognizes that this is our responsibility, the responsibility of these generations to the generations to come. The rights of future generations are not new. One can look into the general comments of different treaty bodies. They have been included and recognized there. By the way, any of the human rights instruments limits the application of human rights in time. That means only to the generation that is living in the moment, because also generations are a continuum, neither in the territory. So another argument for the recognition of extraterritorial obligations. Recently, the Maastricht Principles on the human rights of future generations have done a very interesting exercise of looking into the sources of law that are now there recognizing the human rights of future generations, which include the constitutions of many states, also jurisprudence, but beyond the formal law, also the views of different cosmovisions and faiths. And these principles have also identified other principles that are applied by many courts nowadays that are relevant for future generations, including the principles of intra- and intergenerational justice, the common but differentiated responsibility, the precautionary principle, or the trusteeship principle, all of them used by courts nowadays. And beyond the existing law, also states are practicing. So we do not have only the opinion juries in the courts of many countries, but we have the practice. And this practice includes also, for example, the Commissioner on the Rights of Future Generations on Wales, or, for example, representatives for future generations from the municipal level until the parliamentary level in Spain. I have been participating in some hearings in the Constitutional Parliament where we were bringing the rights of future generations on the discussions on a new law on mining and seeing how this should inform the definition of public utility, for example. So the practice is there. And in some countries, of course, the impact assessment, environmental and human rights impact assessments also look into the long term. So we have a kind of opinion juries that is growing. We have to remember that the work of done for the Maastricht Principles that have been ratified or signed, not ratified, by almost 60 experts of the UN, different mandate holders, like those who are sitting here, is one of the sources of law that the court has to apply according to Article 38, because this is the opinion of recognized international public law experts. And maybe I can finish saying also that the Committee on Economic, Social and Cultural Rights is working on a new general comment that will deal with sustainable development that is also referring to that. And I am mentioning all these sources also to respond to Germany, who said that the rights of future generations are very abstract, that the people that will live in the future, it's very abstract. So I don't know if the judges do not have sons and daughters that will have children, but I think these people are very concrete. So I hope that not only the judges of the Constitutional Court, but also the representatives of Germany consider the very concrete impacts of climate change and the very concrete existence of the people that will succeed us. And finally, I want to highlight that in the recently adopted Declaration on Future Generation, one of the outcomes of the Pact of the Summit of the Future, the declaration is not on the human rights of future generations, but a human rights approach is highlighted there. Nonetheless, we want to emphasize that future generations cannot be taken only as holders of interests or needs. Interests can be defined any way. How Elon Musk defined interest is not the same as a peasant in Colombia, but human rights are very clear and the scope is defined over years. And the most important element that human rights bring regarding future generations is the accountability. Many of you have mentioned a range of accountability mechanisms and remedies. And of course, remedies like no repetition, rehabilitation are very relevant to ensure that future generations can enjoy their rights. So I hope that the court will not let out this relevant element for the advisory opinion. Thank you very much.
Thank you so much, Ana Maria. And for those of you interested in the rights of future generations, And this has been in play for spanning over a century. The commentaries of the Maastricht Principles on Future Generations is going to come out soon, so keep an eye out for that. And Ana Maria, this is going to please you, so I'm going to mention there have been so many strong statements on the rights of future generations in the courts, but Philippines, their whole intervention was great, but they mentioned that at the core of the actions of states and non-state actors is the most basic of all principles, that the fundamental rights of all races and nationalities, present and future generations alike, must with no exception be respected. So moving on, hopeful for the outcome. Thank you so much. We are going to move to a second part of the discussion, which is what is the path forward? We will have this advisory opinion. We don't know yet what it might look like, but we're seeing alignment, a lot of alignment on certain issues. So we could perhaps be a little bit hopeful on some of the issues. What would you say, given that this would still be speculative, of the relevance of the upcoming advisory opinion for the work of human rights institutions and processes, and any lessons learned from the process so far? So I'm going to turn it to Evelyn Schmidt, who is a professor of international law at the University of Lausanne. Evelyn, any reflections? Please go ahead.
Well, thank you, Joy, and thanks to everyone for coming, and congratulations to the organizers and the World Youth for Climate Justice. This is a very broad and difficult question, and I'm looking forward to the debate later on. I think I will break it down a little bit and tell you a specific story about what I think is actually a proxy battle for what Joy just mentioned in terms of this alignment of different courts and different statements being made. And the story is about the judgment of the European Court of Human Rights in Klimaseniorinnen. And I think what we saw in the hearings is, and we actually do have a Klimaseniorinnen right here with us tonight. And why is this important for the advisory opinion as such? It's of course by far not the only important thing, but I get the impression that over the past few days we had sometimes an implicit proxy battle about the narratives of the relevance of human rights in relation that were made in relation to that judgment. Although sometimes I will come to that point, it was actually not mentioned. Because it's the first decision on the merits of an international court in which a court found that a state was in breach of its human rights obligations for lack of climate measures. So if that judgment gets downplayed, of course, that weakens that alignment that Joy mentioned. However, if it gets emphasized, then it may have a far more important effect. So three notable points of, I think, what I saw in relation to Klimaseniorinnen in the hearings. The first, maybe that's the most important message, is that the case has been cited about 50 times by states from all regions, and in the very vast majority of mentions, I'll come to the exceptions, but the vast majority cites that case to emphasize the link between human rights and climate change. So there are references made to positive obligations, to systemic integration of combining the different sources, and to state responsibility. So maybe that's the most important first mention. But then two other points. There's a notable absence. Klimaseniorinnen was not mentioned by the state that was condemned, Switzerland. No word appeared on that ruling in the written submissions nor in the oral pleadings. In the written submission in March, Switzerland mentioned human rights, although to say that human rights bodies could not be required to check whether contracting states were complying with their obligations under the regimes such as the Paris Agreement, which is not really the point because no one asked the European Court to apply as such the Paris Agreement. And then in the comments in August, so after the judgment is from April, in the comments in August, Duarte Agostino is cited, but not Klimaseniorinnen, not the big case against Switzerland in which a decision on the merits was actually made. And Duarte has mentioned the Portuguese case to stress the territorial limitation all without going on that, then the court did say important things about embedded emissions, for instance, in Klimasenioren, about the protection of human rights of a state's own citizens, and by doing that on state responsibility. So that's a notable absence. 50 states citing Klimasenioren in way of alignment, Switzerland not mentioning it. And then maybe the really most frustrating or even embarrassing point is that, as you know, the Swiss parliament criticized the decision. So both chambers of the Swiss parliament criticized the decision as unduly activist, that the court exceeded its legal mandate, and the chambers of parliament asked the government to communicate to the Council of Europe not to take any further steps to implement the judgment. And the really frustrating point is that Saudi Arabia picked this up and mentioned it before the International Court of Justice to say that that human rights are basically not important, not relevant for that advisory opinion. And I think these 3 points tell us something broader about the struggle of human rights relevance in relation to climate change, and also in relation to the potential effects of the judgment in broader ways in climate litigation for those states that have historically participated or been very important in shaping a legal and economic system that drives climate change. I think that's a really important point, and much could be said about the potential very contested or debated effects of that judgment, and then the future advisory opinion on the regulation of corporations and horizontal litigation. There too, the debate is extremely intense. The former president of the European Court of Human Rights, Robert Spano, is telling the world in webinars that Klimasenioren is irrelevant for that question. So there too, there's this proxy debate about what are other courts or other narratives or other actors going to do with that judgment. So I think that space merits to be watched. And maybe if I can end on one more note about the media and communication, because I found that the World's Youth for Climate Justice did a fantastic job. However, somehow it's really difficult to make sure the message of what's actually happening, or even just the existence of those proceedings in media I can only speak for Switzerland, but it was extremely hard, or it continues to be extremely hard to even communicate the fact that this is happening in The Hague. So to conclude, I think, we need to be very attentive of how these references are made. Do they align, or do they downplay the relevance of human rights law? And that we have a challenge for which I don't have a solution in terms of communicating the importance of what is, after all, the biggest proceedings that have ever taken place in The Hague. Thank you.
Thanks so much, Evelyn, for pointing out the complexities and the need to be looking at the case law together. Klimasenioren is so critical. It was really interesting to hear Switzerland argue yesterday and what they were implicitly saying about Klimasenioren, although they did not actually come out and say it. Thank you very much. I think it'll be very important to look at that, and also the role of the ICJ and harmonizing international law will be really important, and the role of narrative, because there is this huge role of litigation in movement building and narrative shaping that is so important. And I do think the international media has picked it up, but absolutely you're right that for it to make a difference in the national level, we need it to filter through to the national, even local media. So that is an ongoing question. Before I turn to Professor Surya Devan, we're so happy you're here, Surya. I just want to mention, just so we have that in mind, because Evelyn spoke about the importance of looking at the cases together, that this is one of the advisory opinions, but we also had the advisory opinion, the climate advisory opinion issued by the International Tribunal for the Law of the Sea earlier this year. That is a really important one to keep an eye on. Also, we are expecting, since this is a human rights audience, the Inter-American Court of Human Rights to be issuing next year, hopefully in the first trimester or within the first half of the year, their climate advisory opinion as well. So we will be looking at a triptych of advisory opinions, and we will need to be looking at them together. So I'm going to turn now back to Professor Surya Deva. Thank you, Surya, for joining us. The right to development came up in very interesting ways in the hearings, and we'd love to get your thoughts on that, Taryn.
Thank you, Joy. Thank you for the invitation. My apologies for being late. An unexpected meeting came. All right, so right to development. I think right to development often is coming in these proceedings in a negative way, I believe. But I would like to frame it that, like any other human right, climate change impacts the realization of right to development as well. That is a common dimension which we cannot ignore. At the same time, what I would like to articulate today is that right to development also provides a concrete basis to articulate the obligations of states. And I'm going to focus on this dimension because this is a dimension which is ignored, both in the argumentation of states convincingly, as well as in the arguments of civil society and scholars, as far as I'm concerned. So let me try to highlight, and I will frame it in relation to the two questions that the ICJ is considering. First question is about the obligation of states. And I will propose that there are 5 elements which are directly relevant to articulate the obligations of states. The first is intergenerational equity. Of course, this principle is well established, but it is closely connected with right to development as well. And if you look at the Rio Declaration, Principle 3, it makes an explicit reference to right to development in relation to intergenerational equity. And of course, you can find that reference to in the preamble of the Paris Agreement, so on and so forth. And if I remember correctly, India made a reference to intergenerational equity in its argument. But of course, you make that reference and then use it in a different way. That is a separate issue. But this is definitely a principle which could be used to articulate the obligations of the states. I guess Anna Maria already spoke. That's where the issue about rights of future generations will come into picture as well. The second is intersectionality. And let us see to what extent the court is going to cover that issue, but climate change does not impact everyone equally. And in my report, and I have some flyers, anyone can take it, on climate justice, that I developed this idea of dual disproportionality. First of all, certain people are impacted differently. And those people, if they are located in a developing country, that is the dual disproportionality. Let's say a person with disability in a developed country is going to be placed very differently from a person of disability placed in a developing nation. And I think that is dual disproportionality that is quite relevant. So right to development articulates a fundamental aspect of human rights law, that is non-discrimination. But Beijing Declaration adds this intersectionality as well. That's where the right to development is again featuring. So I will propose that intersectionality is another angle where the obligations of a state should be articulated very clearly. Third is international cooperation. I mean, often we don't pay enough attention to international cooperation as an obligation. And again, this can be derived from the UN Charter, Article 5, 55, 56. But also the 1986 Declaration on the Right to Development is very explicit on international cooperation. And I think this is absolutely vital in relation to climate change. The other element is CBDR, common but differentiated responsibility. I don't think we can ignore that. Also in relation to just transition and the fossil fuel issues that is there, often the discussion is we should phase out coal. and fossil fuel. And I'm saying, yes, let's go for it. But what about those millions of people who are using coal or oil to cook food? I met someone in Honduras last month when I was in a country visit. So this young woman has no access to electricity. She wants to do online classes at a school. She has no access to electricity. She has no access to internet. Does she have human rights? So if we are talking about phasing out fossil fuels, someone has to provide alternatives. And those alternatives, in my view, have to come from developed countries and those companies that have exploited the planet for much longer and in a worse way. And I think that is where CBDR has to be a core principle. And again, it's recognized in Rio Declaration as well as in Paris Agreement, UNFCCC, and all that. And I believe Ghana made a reference to that principle in the argumentation. My last is about participation. And I think this is most ignored element in terms of the human rights obligations of states. Right to development articulates very clearly that in all decision-making processes concerning the development, people should be able to participate in an active, free, and meaningful way. And often that is not happening. So that is where the obligations, again, need to be articulated in my view. Now, let me very quickly talk about the second question before the court, which is about the legal consequences and what value right to development adds to that second question in terms of legal consequences. In my report, I have articulated that remediation has to be treated as the third pillar. I articulated that in relation to loss and damage. So we should not see loss and damage merely as a charity. It has to be seen as part of access to effective remedy. And we should articulate effective remedy in terms of full reparation. And that is where compensation, restitution, rehabilitation, satisfaction, guarantees of non-repetition, all these are elements of full reparation, especially they are much developed in the Latin America jurisprudence, Inter-American Court and all that. They have to be taken on board in my view. So from my perspective, from the perspective of right to development, it can be a positive force in my view to realize not only the right to development, but also achieve climate justice if it is articulated properly. And often that is not happening on the part of policymakers, on the part of states, as well as legal officers making those argumentation. So I'll stop here for now. Thank you very much for the opportunity.
Thank you so much, Surya. And I have been remiss. I'm sorry. This is Surya Deva, UN Special Rapporteur on the Right to Development. I just take it as a given that everyone knows Surya, but Surya, I'm so sorry about that. No, thank you very much for.
That is what happens to right to development.
Exactly.
It is often left behind.
But not intentionally. Thank you so much, Surya, for those very insightful interventions. And I would love to unpack a little bit with you once we get to Q&A, if we get to Q&A, because I've not been keeping time. How international cooperation has been showing up at the oral proceedings, because it has been showing up in very particular ways. So I'd love to discuss it with you, but thank you so much for those very rich comments. And without further ado, we're going to turn to Ginevra. Sorry, I'm probably decimating your name, but we would love to hear from you. We know that you have an insider's look at the proceedings, and it would be great to have an understanding from you where you see the relevance of the AO going forward.
Thank you. Also, thank you for the invitation and for organizing this event. Just also by way of introduction, I'm a professor at the European University Institute. I also participated in the advisory proceedings as in the team of the African Union. And in this case, I'm now I'm talking in my personal capacity. Just trying to understand the relevance of the advisory opinion. I would say as a starting point that the key outcome is really the clarification of the law on a specific conduct that implies acts and omissions causing significant harm to the climate system and the environment. And these are advisory proceedings, so the court will render an opinion and will most likely address, also in light of the written statements that have been and the oral submissions that have been presented before the court, unpack or address, even implicitly, four legal aspects. The first is the compass, namely the conduct. And in order to address the conduct, we have seen also in written statements, out of 91 written statements, 70 take the position that the conduct at stake implies anthropogenic greenhouse gas emissions, and some also expanded the explanation by addressing the acts and omission causing significant harm to the environment and the climate system. And in doing so, the court may also address the role of science. Science plays an important role in these proceedings. We also know that the court has met with the experts from the IPCC just a week before the oral hearings, which is also unprecedented. We don't know much also about this meeting, but most likely this has been also the result of the fact that many states have submitted expert reports. Also some, for instance, in the African Union case, we also filed an expert report from a member of the IPCC who contributed to the chapter on Africa, on a report that was published in 2022. So the court will also have to explain the role of science in this case. Second, in order to address the first question, the court will try to understand the applicable law, and we have seen a division between delegations, a group that advances the role of the UNFCCC and the Paris Agreement, another group that instead, and this is the majority in written statements that have been filed, 70 written statements argued that the whole body of international law applies, while the minority, 21, argued that only the so-called climate change regime applies. And in this minority, we have some that argued through the lex specialis approach, or others through the saying that is the principal source, or the also through the principle of systematic integration. But now, if the court adopts the narrow approach, that is to argue that the applicable law is limited to the UNFCCC and the Paris Agreement, it would close the door to climate justice. One of the reasons why also the narrow view has been put forward is really to overemphasize the UNFCCC and the Paris Agreement, which entered into force in 1994 and 2016, and therefore also removing a century of emissions, and therefore also historical responsibility is would not be addressed by the court in this way. And in addition also, this would be contrary to the practice of many authoritative bodies. We just heard the discussion, the presentation also on the Klimatsignorinen from a regional body, the European Court of Human Rights, but also at the level of the UN, Billy versus Australia of the Human Rights Committee, together with also general comments like the General Comment 26 on children's rights and the environment, the joint statement on human rights and climate change of 2019. These are all instruments that really provide the court with several answers already given by other bodies. Plus, of course, also the ITLOS opinion that has been rendered just this year. Now, the third legal dimension is the possibility the court could potentially also address the inconsistency of the conduct with international law. It would have to identify possible acts and omissions that could constitute a breach. By way of examples, subsidies for fossil fuels, or in terms of omissions also, not regulating or not adopting measures at the national level to towards non-state actors. And the causal link has also been by many delegations considered as not an element that should be addressed by the court, given that this should be considered as an aggregate conduct, as a composite act under the Articles on State Responsibility, Article 15. The last, most likely the court, we don't know, I don't have the crystal ball. The court may not say that there is a breach, but it can say that if there is a breach, if a breach occurs, then this could be the legal consequences. And then answering question B, and the legal consequences would be, as many of you have already addressed, cessation and non-repetition, and reparation, including restitution in terms of ecosystem, also restoration, compensation, as also the African Union argued, for instance, also debt relief, debt cancellation would be a way of compensating the damages caused by climate change, and lastly also satisfaction in terms of apologies also to victims, as well as tributes or acknowledgement of the damage caused. And as Vanuatu argued, these consequences should be proportionate to the contribution. Now, lesson learned briefly. Lesson learned from the processes. From the perspective of climate justice, there are both positive and negative arguments that have been put forward that from a legal point of view can be relevant also for future cases. The positive arguments are the key role of certain human rights and certain principles, the right to development, the right to a healthy environment, the right of future generations, CBDR, and in terms of also the clarification of the legal consequences. This is something that also judges will feel more comfortable in the future if the court will also provide an answer in terms of what are the consequences that derive from a certain breach related to harm caused by climate change. Then the negative and weak arguments, even dangerous, I would attempt to say. The first is that the Paris Agreement has become a sort of a cage, a safe harbor for high emitters to an euphemism for inaction, I would say, to really address also to, on one side, to argue that cooperation is important, solidarity is important, but on the other side, excluding and circumventing also responsibility. And the arguments related to the right of future generation, abstract persons, abstract risks, as well as with regard to the right to a healthy environment, that there is no common content. This has been argued, as well as the fact that it is a right that is should be applied only nationally. So its implementation is limited to national territory. So again, that would be definitely against and contradicts also the idea of solidarity and of cooperation. Then in terms of broader process, The participation in these proceedings has been historical, and this is something that definitely will be also, it is also for the court, as also the registry has also issued a note reflecting on the fact that the number of written statements have been unprecedented, has been unprecedented. And last element, the narrative used by many delegations in the oral proceedings has been definitely remarkable. The role of the youth, the connection between nature and people, and the role of historical responsibility is something that also certainly has played a role also for the court this week and the past week as well. So I will pause here. Look forward to the questions. Thank you.
Thank you very much, Nevra, for those very insightful comments, for unpacking brilliantly the core legal issues at the heart of the proceedings, and also for sharing your expectations. Thank you. And this is Geneva Limoli, Professor, European Law University Institute. So we are just doing introductions after the fact. So we're going to Nicole now. Nicole is the Steering Committee, World Youth for Climate Justice. They have been accompanying this case from the very beginning and have a very key role in driving the proceedings. So we're very excited to have you with us, Nicole, and we would love to hear from you where you see the relevance of this upcoming advisory opinion for the work of human rights. Please go ahead.
Yeah, thank you so much, Joey, and the organizers for having us. It was nice to see you in The Hague, by the way, and it's such a pity that Vishal from the Pacific Island Students Fighting Climate Change was not able to join the discussion, because they are truly central, especially talking about the appraisal and the path forward. But I'll do my best, and thank you very much for having us again. So when discussing the way forward, the relevance of the upcoming advisory opinion on climate justice initiatives and the work of human rights institutions is especially important to us and our partners, the organization and various youth groups we have collaborated with and who have supported us along the way. Because throughout the journey to the ICJ, I have frequently had to address this question, and rightly so. How is this advisory opinion relevant to people's lived realities on the ground, in our communities, in our advocacies, and in the work that we do? I want to emphasize again the interdependence of human rights and climate justice. The AO is critical for aligning international legal frameworks with the existential needs for justice. And the legal interpretations derived from the AO could ensure that human rights institutions emphasize dignity, integrity, interdependence in addressing climate crisis. At the same time, the AO can address systemic inequities and guide human rights processes in tackling historical and systemic injustices, including colonial legacies that exacerbate climate vulnerabilities. This includes recognizing the intersection of climate change with issues such as the indigenous rights, displacement, and environmental degradation. So to give an example, last year we were invited to contribute to the regional consultation held by the ASEAN Intergovernmental Commission on Human Rights, or the AICHR. At that time, I was asked for my views on the ICJ-AO concerning states' obligations and their liability for failing to take action. So this gave me the impression then that these institutions are indeed looking at and following the proceedings before the ICJ. So I realized that we have a unique opportunity to leverage this AO as a tool in our regions, in the Pacific, Latin America, Africa, and in Asia, to significantly influence and shape regional frameworks on the environment and human rights. This year, together with the ASEAN Youth Forum, Youth United for the Earth, the Asia Pacific Network of Environmental Defenders, the ASEAN Research Institute for Environmental Law, and other key regional actors, we drafted the ASEAN People's Declaration on Environmental Rights. So this declaration emphasizes incorporating a human rights approach to implementing environmental rights and has now been submitted before the AICHR. However, significant challenges remain as we lack an overarching human rights code or a binding human rights charter. When even the term indigenous is contested and argued for exclusion from declarations involving environmental and human rights, it is clear that we have our work cut out for us. So we realize and we know that the AO is not a silver bullet, but we are hopeful that it will help align environmental and human rights framework, inspiring holistic policies that address the interconnected challenges we face. And if there's one key lesson, it is that the importance of adopting a holistic approach to justice. Justice frameworks need to incorporate distributive, procedural, corrective, and social justice dimensions. So this AO hopefully has the potential to help human rights institutions adopt a more comprehensive approach to addressing climate injustices. And I would like to end with that. Thank you all again.
Thank you so much, Nicole. I think that was a great way to kind of end the discussion sessions as well, because you brought it together so beautifully about bringing it home for the people whose lived realities are upended by the climate crisis. So thank you so much for those observations. And we hope that this forthcoming advisory opinion and authoritative interpretation of binding international law can deliver the legal blueprint that we could use to hold major polluters accountable and affirm the right to remedy and reparations. And for many of you working here in Geneva or connected with the Geneva, your work, whether those are on treaties or general comments or statements or reports, they've been relied upon heavily in the submissions, as we've seen, and by those most impacted by the climate crisis in the pursuit of justice and human rights. So for those of you who work very hard to advance the intersections of climate justice and human rights, I hope you take a moment to appreciate that your work is seen and is making a difference. And the questions posed to the court are not theoretical ones. They address legal violations in the here and now, deeply affecting peoples and nations across regions, and are fundamental as a foundation for ambitious and just climate action. Whatever the outcome, the responses to these questions will need to be continually deepened, built on, upheld. Looking forward, Geneva, with its human rights and diplomatic expertise, will have a critical role to play. So we do not have a lot of time left, but I wanted to thank our incredible panelists and discussants and open the floor for maybe a couple of questions, if that would be. We would have a few minutes for questions.
Given the amount of legal issues that the SJ has to consider, for example, recognizing the existence of a right, establishing rights for future generations, extraterritoriality of those rights, which will include the court giving opinions on the legal status and effects of work of UN human rights treaty bodies, for example, lex specialis, applicable law, law of state responsibilities, remedies, as all of the issues that the panel has taken us through tonight. Do you think there are any limitations in the wording of the request for the advisory opinion that risks some of those questions not being answered and some of those legal issues not being addressed?
Thank you so much. That's a brilliant question. And we have a number of incredible panelists. I don't want to assume who will respond. Do we have any volunteers also from our panelists who spoke before? Professor Cohen, Ginevra. We don't have a mic, right? Sorry. Yes.
Okay. Well, It is difficult to answer your question, but the point is, it is true that sometimes the ICJ escaped from the questions raised by the General Assembly by reformulating the questions. I do believe that in this particular case, the questions were carefully drafted, and it will be very difficult for the court to escape from them. This is my perception. Of course, we will see what will happen. But we know, for instance, the nuclear weapons advisory opinion, at the end of the day, the court said, we don't know. We don't know whether the use of nuclear weapons are legal or illegal. I do believe that here, so the need to clarify what are the obligations for states. This is a clear question. So the court can be, can go beyond what was narrowly requested by the polluters. But with regard to the second question, this is the crucial point, as I mentioned, and I believe that the court must address the issue of responsibility for international wrongful acts. The point is, to what extent? And of course, we will see. But I believe that in this particular request for advisory opinion, so the questions do not allow the court to escape. That's my perception. We will see.
If I may, I would like to add one sentence to this concerning the legal consequences that might be attached to a finding of violation of international law. The court will look at this from the angle of international responsibility, but that will not be the only consequence of an advisory opinion, because another major consequence will be that regional courts, domestic courts, will read human rights law in the light of the advisory opinion. And whereas this is an advisory opinion, so stricto sensu, it is not binding on anyone, it will have a major impact in the formation of human rights law. And with the exception, unfortunately, of the Klima Seniorinen versus Switzerland case, most judgments are still, in most cases, considered binding by the states to which they are addressed. And so I believe that the consequences will be especially significant for other courts in other fora than for the international dimensions of the case alone. So that is what I think should not be underestimated. Ginevra, did you want to react to this?
Just one minor comment, but relevant, that the General Assembly also included in the preamble a list of important instruments that will definitely also help and support the court in understanding the broader corpus of international law that should be considered, especially for question one, addressing question one. And as regards instead question B, the wording also refers to the same language used in the articles on state responsibility. So also the fact that that the Assembly also accepted this terminology should facilitate also the court in using this set of instruments to address question B. Despite, I mean, there have been comments that the questions are too general, but I also agree with Professor Cohen that the questions are quite detailed if we look into them with attention. Yes, so I give just the floor.
So we want to be fair to our online participants as well. So we have 2 minutes left, so we're going to be very efficient. But we do want to, this question goes to the heart of some of what is being argued right now in The Hague. So I want to raise it, and then we respond to it quickly. But our online participant says, thank you to the panelists for the insightful presentations. How should international law address the issue of historical emissions when determining state responsibility and obligations for reparations? That's a big one. And now you have 1 minute to answer it. I'm sorry. But it is at the core. Are there any volunteers to respond to it? Yes, Evelyn, go ahead.
But I would just start with maybe one sentence. If the court would only just say that complexity does not mean that the law of state responsibility becomes inapplicable, that would just be a big message. And I just want to quote what Marcelo Cohen said on behalf of Costa Rica at the end of Costa Rica's pleading. That's a small step that is asked from the court. It means to exercise its advisory function fully. But the effect would be a big leap potentially, with effects in various jurisdictions. So state responsibility, the question is if there is a violation, attributable conduct that's for emissions, often actually much more straightforward than would states say, a breach and no circumstance excluding wrongfulness, then that would means that historic emissions are relevant. C'est ça, voilà.
Thank you, Evelyn. And Anna Maria, you wanted to come in quickly?
Yeah, maybe just to say that in the Maastricht Principles on the Human Rights of Future Generations, there is a principle regarding the importance to understand that the evolution of humanity is a continuum, and therefore, to ensure intergenerational justice, it is important to look into all the practices that were creating injustice in the past. That includes also the emissions. So I think the judges have there a principle that can be useful to respond to that question. Thank you.
Thank you so much, Anna Maria. Any last points from any of our other panelists?
To say just a few words. From the perspective of the Articles on State Responsibility, the first consequences that the court could address would be cessation of the wrongful conduct, which would imply stopping actions that fuel the fire, namely expanding and providing subsidies for fossil fuels, as well as also adding regulatory measures that could help achieving immediate and deep emissions cuts. In addition, assurances of non-repetition, and lastly, reparation, proportionate to the historic contributions to the harm. And
thank you so much, Ginevra. And I'm sorry to rush the responses to this very critical question, but we're at time. So thank you very much to our incredible panelists, the discussants, the very rich contributions, and to the co-organizers, and also the wonderful audience. Thank you very much to all of you.